Hey, I'm Marc Stevens, author of Government Indicted. The website, of course, is marcstevens.net. And finally get this video to go with the article, which was published a little premature, so I'm just not even going to bother changing the title. It was a tentative title, but I hit publish instead of preview, so we got the article well in advance of the video. But here, I finally have the time to do this. We're going to be debunking the claim territorial / personal jurisdiction, why it doesn't exist, and how to debunk this garbage. When typical status crap comes up when you start talking about jurisdiction. So the two main arguments that I want to address here that critics love to throw out are one, jurisdiction requires no evidence. It doesn't require any evidence to prove that the Constitution applies. It magically does. Magic. Two, not in Germany, jurisdiction, for those critics who claim it can be proven with evidence, believe it's so easy that a child can do it. It's extremely easy to do. They think that all they have to do is prove that you were physically in Arizona, then, or by extension, the magical Constitution applies. So I'm going to have the documents in the video regarding an appeal from Marc in New York, and this is actually from a New Jersey Court of Appeals, so I'll have those documents they're already in the article, and I'll have them here in the video. So let's just discuss first what jurisdiction is. Jurisdiction is the power of a court to adjudicate court cases and issue orders to its also territory within which a court or government agency may properly exercise their power. And I'm taking this from the Cornell School of Law, which is why people have asked, what's the deal with Andy Bernard? Because there's so many Cornell references in the article, the first thing I thought about was Andy Bernard. So that's why he's in the thumbnail. Cornell Law School is also saying, and I have this linked in the article, the term jurisdiction is really synonymous with the word power. Any court possesses jurisdiction over matters only to the extent granted to it by the Constitution. That's why we talk about the Constitution. If you're physically in Arizona, they believe their laws apply to you. That's, no evidence. Magic. Okay, so personal jurisdiction is also power over the man or woman. So like territorial jurisdiction. Territorial jurisdiction is the court's power to bind the parties to the action. So it's power over the person. That's personam jurisdiction. So, of course, the Constitution is the basis of the jurisdiction. That's, no one's debating that. The only issue is these two arguments that, one, it doesn't have to be proven. Now, you could just claim the Constitution applies to somebody because they're physically in Arizona. You don't need any evidence to prove that. Well, that's absolutely ridiculous. Because not only is it an issue of jurisdiction, it's an element of the charge. Because you can't prove that somebody violated the code if you can't first prove it applies in the first place. And just saying and alleging that it applies, that's not evidence, that's not proof. That doesn't make it true. So there actually has to be proof, and we'll go to see what the courts actually say about this. Now, I know this is talking about federal jurisdiction, but the principle is the same. Federal courts are courts of limited jurisdiction. They possess only that power authorized by Constitution and statute. So whether you're talking about a federal court or a state court, they still only have that power as authorized by written instruments called constitutions. Okay? It's not to be expanded by judicial decree. It is to be presumed that a cause lies outside limited jurisdiction. And the burden of establishing the contrary rests on the party asserting jurisdiction, which is the plaintiff or the prosecutor who claims to have and represent a plaintiff when, of course, we know that they actually don't represent anybody but themselves. So there's a little more, some evidence to show that there has to be proof to support your claim. We also go to Rule 3.1 of the Professional Rules of Conduct for attorneys. A lawyer shall not bring or defend a proceeding or assert or controvert an issue therein unless there is a basis in law and fact. So law and fact. If you're going to say that the law applies, you have to have some facts, you have to have some proof, not just because you said so. And we also have Rule 11 of the Rules of Civil Procedure, which states that every pleading motion, written motion, and other paper must be signed by at least one attorney of record in the attorney's name or by a party personally if the parties are represented. The paper must state the side's address, blah, 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 blah. By presenting to the court a pleading, written motion, or other paper, whether by signing, filing, submitting, or later advocating it, an attorney or unrepresented party certifies that to the best of the person's knowledge, information, and belief formed after a reasonable inquiry under the circumstances, that the claims, defenses, and other legal contentions are warranted by existing law or by a non-frivolous argument, blah, blah. The factual contentions have evidentiary support. You've got to have some facts. The denials of factual contentions are warranted on the evidence. So when we say it's just a written instrument, okay, it'd be lying to deny that, any ethical violation right there. Then we have, for the criminal side of it, because Rule 11 is just for civil procedure, we have, whether in or out of the United States, it's an abusive process. It is obstruction of justice. It's a felony. And it's called prosecutorial misconduct. Yes, that's right. Prosecutorial misconduct. And it doesn't matter what, in the case below, it doesn't matter what the prosecutorial misconduct was in this particular case, because every case is fact specific. But this is the definition of what prosecutorial misconduct is. Now, critics will turn around and say, well, that has nothing to do with what you're talking about with these IRS prosecutors, because the case in De Robertis dealt with completely different issues. Yeah, no kidding. But we're defining what prosecutorial misconduct is, and it's very, really simple. By going outside the evidence, the prosecutor violated a fundamental rule known to every lawyer that argument is limited to the facts and evidence. And that includes the argument that the Constitution applies to me because I'm physically in Arizona. That's an argument. It's an allegation. It's a legal opinion. Must be based on evidence. Unless, of course, like I covered in the previous video, you're raising a theoretical issue of law. So, again, real briefly, if you say, hey, is it a denial of due process to deny an effective cross-examination? Yes, we could just look at any number of court cases and that's yes. But when you say, did Angel Lopez violate due process? Now you got to have some damn evidence. You can't just say, oh, he denied effective cross-examination. You have to have statements of fact. You have to have the evidence to back it up. So we will generally be able to do that by asking a question, hey, what evidence do you have that the Constitution code apply to me just because I'm physically in Arizona? The prosecutor is out of his chair objecting. Objection calls for legal conclusion. The witness can't answer. He's not qualified to answer because he doesn't have personal knowledge. And then the judge grants the motion without explanation, and you ask to have the testimony stricken from the record. In a fit of blinding rage, the judge refuses to strike the testimony, ends the cross-examination, and says, that's it, we're done here, you're guilty. Those statements of fact will lead a reasonable person to believe that an effective cross-examination was denied, especially since we asked for the facts the opinion was based on that he made at the traffic stop, not another legal conclusion. So those are our statement of facts that support our legal conclusion that the judge violated due process. Okay. So clearly you have to have evidence. Anyone who says they don't have to have evidence, they're dishonest. They're crooks. They're trying to fool you. They think they have to prove it beyond a reasonable doubt. And as we'll see later, even the judges admit jurisdiction is an element of the charge that must be proven beyond a reasonable doubt with evidence and witnesses. So now the second part is that it's easy to prove. Well, they claim this because they think that just showing that you will fit, like to say Marc, for example, was just by showing and having the officer's testimony, maybe have some body cam images, that the police officer physically saw Marc in New Jersey. They believe that that's all you need to do to show that the Constitution applies. And that's not true. It's a written instrument. How does a written instrument apply to me just because I'm physically in New Jersey? Before you start saying, but the people agreed, no, they didn't. All support is compulsory. There is no agreement. I don't want to hear about my roads and things like that. it doesn't address the argument, or it doesn't address the facts, and it doesn't defeat the argument. So what they are actually doing, of course, when they do that, is they're presupposing that their argument is true. That just because he's physically in New Jersey, the Constitution applies. Well, just because you're physically in New Jersey, it's a non sequitur to say that the Constitution applies. There has to be something to bridge that. There's a huge gap in the logic there. And it just, no one's been able to explain that other than to say that's just the way it is. So, alleging that Marc violated the code presupposes that the code applies in the first place. It doesn't prove that the Constitution applies. So, alleging someone violated the law is in no way evidence proving that the Constitution applies. I mean, that's just basic common sense. So what we have here is we do have the appeal documents. I didn't include the entire transcript. It wasn't necessary. And Marc did give me permission to do this. Of course, you can see I redacted where necessary. So if the judge does agree that jurisdiction is an element of the charge, and as an element of the charge, it's supposed to be proven with evidence by a competent witness. So even in New Jersey, Rule 602, no one may testify to a matter unless evidence is introduced to show that they have personal first-hand knowledge of the matter they're testifying to. Does the police officer have personal first-hand knowledge that the Constitution applied to Marc just because he was physically in New Jersey? No, and the judge agreed, because he sustained that objection that the witness was not qualified to make such statements. So where was the judge making his determination if it wasn't based on the evidence from the prosecutor? Oh, that's right, because he assumed an element of the charge, didn't presume innocence, and held that the claim from the prosecution was irrefutable, which of course is a due process violation, Volandis first claim. Yeah, I know that dealt with legislative presumptions, but I'm sure the principle is equally applicable to a police officer on the street or a prosecutor and in court, because if the presumption is irrefutable, then it's a rigged game. Okay, so we get down here. Okay, so now the judge knows that there has to, because he admits it, he knows there has to be evidence from the prosecution and witness, but he seems oblivious to the fact that he, including the previous judge and the prosecution, all presumed an element of the charge as irrefutable. Not a single fact from the prosecution. This is not what happened, of course, in Indiana, which I mentioned. So here you can see the judge is just assuming this. And it didn't matter how many times that Marc objected. It didn't matter that the police officer was declared incompetent. There was no showing beyond a reasonable doubt at the trial that the Constitution applied to him just because he was physically in New Jersey, because the judge presumed the rest of it. He presumed that just because he was physically in New Jersey, the Constitution applied, a written instrument. That's not logical. It's called a non sequitur. That's exactly what the judge did. So here you can see the judge, knowing it has to be proven with witnesses, knows the witness was impeached, and went based on his own prejudice anyway. But that's what they do. I know it's not, I'm not thinking that because they're going to set a precedent, because they ruled in Marc's favor when they set a precedent. Holding a prosecutor to their burden of proof doesn't set a precedent. Maybe in one sense it does, because they very rarely do that. It's not like the judge in Indiana, where they did hold the prosecutor to their burden of proof, and the one in Wisconsin that held the prosecutor to their burden of proof and granted the motion to dismiss. But that, in summary, it seems pretty clear that, one, you do need to have evidence to support your claim, especially since they have to be proven beyond a reasonable doubt. Arguing without evidence is a crime when you're in court, or administratively, because you're affecting someone's life. It's an obstruction of justice, on top of what you may be actually stealing from them. So the idea that you don't have to prove your claim, fungal. That's just the ravings of criminals. Don't take it for a second, and don't think for a moment that, I'm just confusing, and Marc is confused. I'm confusing law and evidence. No, I'm not. No, you're saying a written instrument from 200 years ago applies to me. That is a claim, that is an allegation, and as any other allegation, it must be proven by evidence. Quoting a statute presupposes your argument is true. Quoting a court opinion is conflating res judicata with stare decisis. So, no, I'm not confusing the two. If you claim that if your argument is you can make a claim without any evidence, then you're just a dishonest crook, and you're a shameless apologist for people called government. Which, of course, we know there is no government. There's just men and women forcing us to kill us, forcing us to pay them, or they'll kill us. And anyone who thinks that's wrong, anyone who thinks that there is a government, you're more than welcome to call into a live broadcast. We do 4 hours a week now here on the No State Project. If you've got evidence of reciprocal obligations of allegiance and protection, I love to see it, because it's the only way you're going to prove that there's a government, and the only way you can follow your silly logic to say that the laws apply to us because we're physically in Arizona. So you're going to have to overcome that. Overcome the fact that they're just men and women forcing us to forcing us to pay them. So the other side of it too, we showed that was false. That's easily proven if you're just accused of violating the law within a certain territory. No, that is only part of it. You still have to explain and show facts showing why a written instrument would apply to you just because you're physically in New Jersey. And again, the people did not agree. We all know, and all the critics will agree, taxation is compulsory. You pay or you go to jail. So that's debunking that. There is no such thing as territorial jurisdiction or personal jurisdiction, even subject matter jurisdiction when it's a code violation, because there isn't a shred of evidence that their magical rules apply to anybody. And again, if someone disagrees with that, we do a live broadcast 4 hours a week, 3 on Saturday and 1 on Wednesday. And you're more than welcome to call in. I await your evidence. If you have a problem with the logic and how I've broken this down, my analysis, please call the show. Again, my name is Marc Stevens. The radio show is the No State Project, and the website, marcstevens.net.